Welcome to the Deep Dive, our ongoing series where we try to, well, make sense of U.S. patent law.
One section of the MPEP at a time.
Exactly. And today we're diving into Chapter 2100, which is all about patentability.
And specifically, Section 2129.
Right. Section 2129, admissions as prior art.
Yeah, this is a fascinating one. It's all about how things you, the applicant, say during the process can actually be used to determine if your invention is patentable. Even statements about things that might not technically be prior art otherwise.
Okay, so our mission today is to really understand what counts as an admission of prior art.
And crucially, the exceptions and the nuances, because it's not always straightforward.
Let's start with the core concept then. What does Section 2129 actually say?
Well, the basic idea is pretty simple on the surface. If you, in your patent application...
Look in the written description, the spec.
Right, in the specification, or maybe during the back and forth with the examiner, during prosecution.
Okay.
If you explicitly identify something and call it prior art...
You just say this is prior art.
Yes. Then the USPTO can basically take your word for it. They can treat that thing as prior art against your claims.
Even if maybe technically it wouldn't meet the definition under the law, like 35 U.S.C. 102.
Exactly. Your admission trumps that. You've essentially conceded its relevance as prior art.
So you could potentially set yourself up for a rejection based on anticipation or obviousness just by labeling something incorrectly.
You absolutely could. It gives the examiner a basis to use that information against your claims.
Okay, can you give us maybe a hypothetical example? Make it clear.
Sure. Let's say you've invented a better mousetrap. Standard example, right?
Classic.
And in your application, you describe an older mousetrap design from competitor X.
Okay.
And you write something like, the competitor X mousetrap is prior art in this field, and my invention improves upon it by.
Ah, okay. You've explicitly called it prior art.
Precisely. So now the examiner can look at that competitor X trap based on your admission and say, well, is your invention actually new compared to this admitted prior art?
Or is it just an obvious modification?
Exactly. Even if maybe that competitor X trap was some obscure internal document that wouldn't have otherwise qualified under Section 102, your statement made it fair game.
Wow. Okay, so the words you choose are really critical.
Incredibly so. It's not just the technical invention, it's how you frame it against the existing landscape.
But you mentioned exceptions. This sounds like a potential minefield, especially if you're just trying to provide context. What about your own earlier work?
Right, this is probably the most important caveat. It's treated very differently.
How so?
If the thing you referred to as prior art is actually the inventor's own earlier work.
Like a prototype I built, or an earlier version.
Exactly. That statement calling it prior art doesn't automatically make it usable against your claims in the same way.
Okay, why the difference?
Well, the rule is your own prior work can only be used against your claims if it independently qualifies as prior art under the statute.
Meaning, if I had already published it or sold a product based on it before my invention date for the current application.
Precisely. If it was already public knowledge according to the law, then fine. But if it was just your own unpublished research or development, then simply describing it, even if you perhaps loosely called it prior art when explaining your inventive journey, doesn't make it statutory prior art against you.
That makes sense. You shouldn't be punished for explaining how you got from A to B.
Exactly. Inventors need to show the progression, the improvement. The courts agree, too. There's a case, Reading and Bates construction.
Oh, yeah.
Yeah, the court basically said, look, it's common sense. An inventor knows their own prior work. Referencing it doesn't automatically mean it's fair game to use against them unless it was already public.
Okay, so that's a huge relief for inventors describing their own development process. Don't call your own non-public stuff prior art, but even if you slip up, there's protection.
Generally, yes. The key is whether it independently meets the Section 102 requirements.
Got it. Now, are there other ways admissions can happen? You mentioned explicit statements. What about implicit ones, like through the claim format?
Yes, that's the next big area. Jepson claims.
Ah, Jepson claims. Explain those quickly.
Okay, so a Jepson claim has a specific structure. It has a preamble.
The introduction bit.
Right. And that preamble describes the elements or steps that are supposedly already known in the field, the existing context.
Okay.
And then there's the body of the claim, which starts with phrasing like, wherein the improvement comprises, and lays out the new part, the invention itself.
So by putting stuff in the preamble, are you implicitly saying, hey, examiner, this preamble stuff is old news, it's prior art?
That's the potential implication, yes.
Oh.
The format itself can be seen as an implicit admission that the elements in the preamble are prior art.
Can be seen as, that sounds like it's not automatic.
It's not. And that's crucial. It's an implication, but it can be rebutted.
How do you rebut it?
Well, you might have a good reason for using the Jepson format that isn't about admitting the preamble is prior art.
Like what?
A common one is to avoid a potential double patenting rejection.
Ah, right, where you might be seen as trying to patent the same invention twice.
Exactly. So you might use the Jepson format to clearly delineate your improvement over something closely related, maybe even your own earlier patent, specifically to address that double patenting concern.
And the MPP acknowledges this kind of situation.
Yes. The guidance suggests examiners should consider such explanations. If you use the Jepson format to, say, navigate double patenting issues, that weakens the argument that the preamble is a definitive admission of prior art. You might even state explicitly in the application that the format is used for clarity or another reason, not as an admission.
Okay, that's another really important nuance. Structure can imply things, but context and explanation matter.
Absolutely.
What about information disclosure statements? IDS, you have to submit these, listing things you know about that might be relevant.
Right, duty of disclosure.
Does listing something on an IDS count as admitting it's prior art? Because that seems like it would discourage people from being thorough.
Great question and a really critical point. The answer is a clear no.
No. Okay.
Simply listing a reference, a patent, a publication, whatever on an IDS form is not an admission that the reference actually is prior art under Section 102.
Even if it's your own previous patent you're listing.
Even then, there's another key case here, Riverwood International.
What did that say?
It explicitly held that listing references, including your own prior patents, in an IDS doesn't convert them into admitted prior art. They still need to qualify under the statute on their own merits.
So the IDS is just about informing the examiner, fulfilling your duty.
Exactly. It's about candor. You're saying, here's stuff I'm aware of that might be relevant. You should take a look. You're not saying, and by the way, all of this definitely counts as prior art against me.
Okay, that is a massive relief. You don't accidentally shoot yourself in the foot just by being honest on the IDS.
Correct. It's a procedural requirement, not a substantive admission in itself.
So, pulling this all together, it sounds like the examiner has a pretty significant role in interpreting these situations. It's not black and white.
Definitely not. Context is absolutely key. And the MPEP emphasizes the examiner's responsibility to evaluate that context.
What are they supposed to be looking for specifically?
Well, first, is the reference being discussed the applicant's own work or someone else's? We know that changes things.
Right.
Second, is the applicant's statement factually supported? Did they describe the reference accurately if they're calling it prior art?
Makes sense.
And third, especially with implicit things like Jepson claims, are there credible explanations or reasons provided by the applicant that might rebut the implication of an admission?
So they need to weigh the evidence, consider the applicant's arguments.
Yes, it's an evaluation, not just ticking boxes based on keywords like prior art.
Which brings us back to you, the listener. Why does understanding Section 2129 matter so much?
Because it directly impacts patentability. If you're an inventor or you're helping inventors as an agent or attorney,
Or even just studying patent law.
right, you need to know how statements made during prosecution can create prior art, potentially blocking a patent. Understanding these rules helps you draft applications carefully, respond to office actions strategically, and avoid inadvertently creating obstacles for yourself. It's about navigating the process effectively.
Okay, so let's try to summarize the big takeaways from Section 2129.
All right, first, explicitly calling something prior art generally means the USPTO can treat it as such. Be careful with your words.
But second, there's a big exception for the inventor's own non-public prior work. That doesn't automatically become prior art just by mentioning it.
Correct. Third, things like Jepson claims can create an implicit admission, but that's rebuttable with good reasons.
And fourth, crucially, listing something on an IDS is not an admission.
Absolutely. And finally, the examiner must consider the overall context.
Great summary. Now, as we wrap up, maybe a final thought for our listeners to sort of chew on.
Okay. Consider this scenario. An inventor is maybe having an informal interview with the examiner, trying to explain their invention's development.
Right.
And in trying to differentiate, they casually, unintentionally, refer to an earlier non-public prototype as Part of the prior art I was improving on. A slip of the tongue, maybe?
Oh, okay. Even though it wasn't actually prior art under the law.
Exactly. So under Section 2129, what kind of trouble could that informal, potentially misconstrued statement cause?
Hmm.
And maybe more importantly, what steps could the inventor or their representative take afterwards to clarify the record and correct that potential misstatement before it becomes a real problem?
That really drives home the need for precision and awareness throughout the whole process, doesn't it?
It really does. Every communication matters.
Well, this has been incredibly insightful. And remember, this deep dive is just one piece of our larger series exploring the MPEP.
We definitely encourage you to check out other sections for a broader view of U.S. patent law.
And before we go, a very special thanks to Mike Shepard. He was the creative director behind this whole project, and his leadership really made the series happen.
Yes, thank you, Mike. And one final important point. Please remember this discussion was generated using AI tools.
Right. It's for educational and informational purposes only.
It might contain errors or leave things out, and it is absolutely not legal advice or a substitute for formal training.
For the official word, always, always, consult the official MPEP itself, talk to a qualified instructor, or get advice from a registered patent practitioner.
Definitely stay informed, stay careful.